judiciary is not in any capacity able to enter into any agreement with the executive, especially in a matter that is before court. The judiciary was not a party in that cause, and I tried myself to look at the clip where His Excellency the President was quoted to have said he entered into an agreement with the judiciary. I'm a judge, I'm not a communication expert, but all I could say or deduce from that conversation is that it was taken out of context or there was misinterpretation, because what His Excellency was saying is that he agreed with the judgment of the court that gave directions on what needed to be done to create a framework on how to administer the housing levy. And what he was telling Kenyans is that the executive has complied with the directions given in the judgment to come up with a framework, which is the Housing Levy Act. I would like to assure Kenyans is that the judiciary was not a party in that matter. The judiciary was discharging our function of determining a dispute which was before us. We are independent, we are impartial, we were not parties to the case, therefore we had no capacity or local standard, as they call it, to enter into an agreement with the executive. Thank you. In the first half of 2023-2024 financial year, this court posted a rate clearance of 166% of the cases that were resolved. This was really commendable, because out of in the same period, 2,060 cases were filed, and you were able to resolve those 2,060 cases in terms of numbers, and went beyond, actually, because you resolved 3,414 during the first half of this financial year. I would be remiss of me to conclude without addressing the question of the proposed constitutional amendment that seeks to merge the two specialized courts of equal status with the High Court. I understand this discussion is live, and I have already written to the leaders of our parliament expressing the judiciary's position, opposing most vehemently the mixed grill approach as proposed in the proposed constitutional amendment as not being ideal. There was an informed reason why Kenyans during the constitutional making process demanded for a specialized attention to the areas of employment and labor relations, and also environment and land. And that rationale has not gone away. We are just scratching the surface to deal with our labor issues, and therefore we cannot revert to the old practice where the cases of labor were piling up in our system. The contribution that we have seen from the two courts is a testament to expeditious delivery of justice, and also the development of a robust jurisprudence in these areas of special concern to Kenyans that actually justify the continued existence of the two specialized courts. So rest assured that we will not allow any amendment to the Constitution to take away our labor and labor.
As a ministry, you have afforded us much relief in the many landmark decisions on diverse and complex matters without mentioning any in particular. We also the types of employment, organization of work, employment relationships are quickly evolving, and and there is no doubt there is need to adjust the legal framework for promotion of justice, equity, and industrial peace and harmony. We must defend and promote labor rights in the platform of work, remote working, and in other typical forms. Our laws need to accommodate all workers without distinction and to ensure that all workers are afforded dignity, security, and fair treatment. Currently, we are finalizing on partnership arrangements with a number of partners, including the European Union, the US Department of Labor, the ILO, to enable us kickstart the process. Madam CJ, it is not only you who complains of the budget, we also complain. And so, once in a while, we also partner with these stakeholders to be able to support us in some of the activities. The achievements made in ensuring that justice is served in the labor sector, there is a backlog of unresolved cases, and the use of ADR, court annexed mediation, has been particularly useful in restoring peace and order in the labor sector. We need to enhance our efforts towards this direction, and we will be inviting you soon for a social dialogue forum to explore ways and means to achieving the desired results, especially within the pre-court process. It is imperative that we address the existing hurdles urgently to ensure that citizens are not denied their constitutional right to access justice.
Over a period of the during the financial year 2023-2024, July to December 2023 only, the caseload statistics report that I looked at showed that the court, that is my court, the Court of Appeal, had 8,443 pending civil appeals. And of those pending appeals, 1,334 are appeals emanating from the 21 judges of the Employment and Labor Relations Court. From Nairobi alone, over that 6 months period, we received 891 appeals. And these are appeals that are coming to 2 civil benches, literally coming to 2 judges, because we have only 2 civil benches in Nairobi.